right, welcome back, everyone. New faces, welcome to our discussion. So my name is Maria Weimer, and I'm chairing this session. And it is my pleasure to present to you our two speakers. So we have Vigjilenca Abazi, who is a tenured assistant professor of European law at Maastricht University, at the law faculty there. Vigjilenca teaches and writes about EU law, whistleblower law, privacy, and cybersecurity, among other things. She has been the recipient of the Royal Netherlands Academy of Arts and Sciences Prize for Early Career. It's an award for early career achievements. Wonderful, congratulations, and has also been the recipient of the many research grant. I believe that was on AI as well, wasn't it?
Sort of privacy, whistleblowing.
Yeah, whistleblowing, that's it. That's okay, wonderful. So Vigjilenca will open, and I will briefly also introduce you, Maria. So we also have Maria Lee from UCL. Maria is professor of law, and your major work has been in the field of environmental law. You're the author of several books on European environmental law, and you have been in my PhD defense, and so it's particularly dear to me to be during this session today. All right, so Vigjilenca, I will open the floor.
Is this on, or do I don't need it?
I don't think.
I mean, similarly to Christina, I feel like my vocal cords are very strong, so I feel like I don't need. Great. So I just didn't know if I should have this closer. Well, thank you, Maria, very much for your very kind introduction, and thank you very much to the organizers for the invitation. And Kiara, congratulations also on this very fascinating project. I also have to remark that on the 8th of March, having an almost all-female conference, I don't know if it was accidental. Thank you, Thomas, for being our token of the day. Looking at the program, I was like, okay, this is fascinating, but excellent discussions. I'm very delighted to be here. Especially because to be frank, it's been a few years actually that I haven't so actively worked on expertise angle of things, sort of maybe being the legal expert more so and practice more than the topic. But some years ago, we did do kind of a similar endeavor of a conference with colleagues Johan Andriansen and Thomas Christiansen that kind of resulted in this book, The Contestation of Expertise in the European Union. Some of my remarks will draw from the insights that we have here. And it has been it was an interesting point, especially at the time, this was closer to the Brexit, around really the very strong contestation against expertise. So in the themes of today, sort of the place of expertise in EU policymaking, what I want to sort of focus on is start with some of the assumptions that are, I think, very familiar to most of us in this room around the place of expertise in the EU and its growing contestation. Move a bit further with reflections around what the current context provides us, especially as also the title sort of my presentation is on disruptive politics and transformative AI, and what does that mean for knowledge production and for accountability of expertise in the EU, and then move on with what have been the EU's way of coping with some of these pressures around contestation of expertise, and rather what I would think would be a possible interesting way of thinking around one of the mechanisms that we can potentially consider in drawing where and how contestation can take place. So to begin with, so sort of the assumptions part. I think we all kind of recognize, and in Paivi's excellent keynote today, that was even more evidently shown, how essential the place of expertise in the European Union has been. Because as we know, sort of from the literature around sort of input-output legitimacy, the EU's always has sort of drawn its legitimacy much more by supposedly delivering, so problem solving. This notion of problem solving for the EU has been essential in terms of why it has an added value and why it should exist. And central to problem-solving capacity is, of course, the place of experts and expertise in policymaking. And so largely legitimizing around this tension, well, the EU is justified to take this action, not only because it makes more sense to take this particular coordination directive, whatnot, at the EU level, but also because of the required expertise and sort of the complexity around issues. Now, I can give a countless number of policy fields in which we see this. Definitely the current issues around more AI, or of course privacy, that's sort of part of also of my work, very much show that the EU wants to sort of showcase its sophistication as a legislator, so to say, through its sophisticated expertise. And of course, as colleagues around sort of this notion of the Brussels effect have also explained, the EU draws that legitimacy around its expertise, not only internally within the EU, but also globally by saying this is sort of the pathway around which these are the most thought through or value-based kind of solutions that we should be drawing. And of course, especially around GDPR, it's very hard to dispute its impact globally, of course, with a lot of countries taking on its model. It is questionable, but outside the scope of today's talk, to what extent that's really willingly done so by other countries, or to what extent EU's market force or trade agreements, like we saw with Japan, for example, and other instances, that is also done through the influences that the EU can exert. But nevertheless, my point here is to say that sort of this a combination around problem-solving capacity and the essential place of expertise here is being legitimized both from Brussels vis-a-vis national capitals, but also increasingly that legitimization in Brussels is found through this global perspective around the EU as a sophisticated lawmaker that draws from this very sophisticated expertise. Now, if expertise, and we can agree that it has been so essential to you, increasingly the place of expertise is contested. Of course, contestations around calls, such as by EVs around critical reflection of how this is drawn, or sort of the role of academics or institutional lawyers around that, that's one topic, and that's not what I'm referring to. I'm more referring to the sort of contestation of a deeper level, which is whether indeed it should be at the and to what extent it's too much trying to take place, the democratic deficit that the EU has, and sort of overcorrecting by providing sort of too much focus around expertise-based developments. And the book that we did, and we were looking at very different structures, different institutions from the Commission, Parliament, agencies, different policy fields, very much actually shows the sort of interesting perspective around how the contestation has taken place and what EU's response has been. So before I provide sort of more of a contemporary, if I could say so, a discussion around what I'm calling an outside-in reflection of these external developments of disruptive politics and transformative AI, let me kind of pause at the three logics of contestation that we identified and how those took place. So the first one, and goes along the lines of what we heard in the keynote as well, is sort of these, what we're calling epistemic critiques around sort of how the knowledge production is conducted. Who are the experts? How are they selected? Who gets to select them? What is really required? What kind of knowledge are they producing? And of course, this especially comes across in terms of who has access to the key institutions and sort of what kind of findings these experts are producing. The second set of critiques is very much a normative critique around the implications of expertise. And this we also heard in much more detail during the keynote around the sort of justifying actions and to what extent this is actually appropriate or not. And the last one is sort of the structural critiques that are focusing much more on the contextual features and procedures by which expert positions are created. So let me this sounds a bit very vague. Let me give a few examples around where do we see that. So one thing that, one manner in terms of the latter example, the structural aspect, is very much the process of agencyfication always very many Asians in the sentence. So the growing number of bodies and the growing number of coordination roles bodies that actually take over, but this further and further decentralizes in a way, if you'd like, the space around where expertise is made and the way and the expertise can be contested. So, but some authors have called it sort of diffusing the contestation of expertise, and therefore leading more to this, as we've seen also, notion of lack of transparency, lack of being able to really have a more common and democratic debates, because simply not only do we sort of leave this on a technical level, but we also decentralize it to such extent, we specialize it to such an extent that we create the structurally difficult, an impossible difficulty in terms of contesting or engaging with even the expertise that's created. In terms of normative critiques, and I've seen this a little bit myself with the position around the whistleblower directive, the Commission moved 180 degrees from very clearly, explicitly saying at the time, Commissioner Malmström, publicly noting, the European Union has no competences, I'm almost quoting, I think, to deal with whistleblowers. And this was immediately after the LuxLeaks scandals around over 340 companies in Luxembourg being discovered to be part of tax schemes evasions. And of course, this backfired very much at the time for President Juncker because he was prime minister and then head of the commission. So it was a very sort of a challenging position to be in. And we went on in a scale of 2 years from that position to, oh, here are these 11 legal bases. That's how many the directive has, rooted primarily in the internal market against the fine legal advice, which was supposed to be workers' perspective, but okay. And to sort of say, oh yeah, of course we can do this and we should be doing this. And look at the millions of euros that taxpayers' money are lost on the EU basis around which we should be saving. Of course, it was a sad in a way factor that 2 journalists at the time, within a span of a year and a half, were murdered in Malta. Kafna Galicia's car was said to explode in the middle of the day. And in Slovakia, Jan Kuciak was assassinated together with his fiancée, which eventually led to the overthrow of the government and the first actually lawyer, an anti-corruption lawyer, had as president in Slovakia. So these were very fundamental events. So it had nothing to do per se only with the expertise. The political impetus became too strong to only allow that. But it was also very interesting to observe that the legal expertise very much became part of that conversation and drove that conversation. And I very much appreciated Paivi's phrasing of strategic expertise, because actually here, the Greens in the European Parliament were particularly instrumental in being sort of ahead of the game by not only providing a memo around why the EU should act, but also providing a model directive and sort of really trying to say, yeah, this is how an EU law could look like, so it's not impossible and we should be doing. The point in terms of expertise and contestation here, therefore, is that these moves are so sophisticated and the players know the field so well that very much the democratic debate around the lawmaking or that procedure, there is no venue really generally for that. So essentially what I'm trying to sort of say by pointing at these examples is to sort of point at the lack of place of the conference name, the workshop space is the place of expertise, but also I suppose my intervention is also focusing a lot on the place of contesting or possibility of contesting expertise. And that increasingly in the EU, as I'm making a point, is either diffused or very difficult because of intransparency or because of a very sophisticated way in which the procedure moves. So then aspects of procedural transparency, which I will address in a moment, become slightly vague or formalistic in actually addressing genuine possibilities of contestation. Maria, I hope I'm okay with time. Yep. So it's kind of trying to not get carried away. So moving on, so to sort of perfect. So moving on exactly to that sense of saying, okay, expertise is important. It has been actually fundamentally essential for EU's legitimizing as an emerging polity. the way we can contest EU expertise is increasingly problematic. And I would like then to add some external factors around which this even becomes further difficult. And that is what I'm calling disruptive politics and then transformative and sort of the trends around AI. We have to be, I would also add a note of caution here, because I don't want to sort of only look at what possibly can be a question of a trend. Okay, populism can always exist, sometimes maybe in a more heightened form. To what extent are we drawing our analysis or ideas around something that maybe is simply a trend of a time, but not very fundamental in the structural sense? Same for the AI. To what extent is it sort of the GDP chat mania kind of just a thing of a moment, or to what extent it's really fundamentally changing something about knowledge production? And my point is actually that it's not a trend. And in the book also we show, particularly with regard to disruptive politics, how much it's become very much rooted, because it's not anymore only sort of sidelined populist notions around the people versus the experts. It is very much part of the discourse around not taking for granted the fact that the role that experts will have in decision-making in the European Union, and to what extent sort of, one could say, more artificial mechanisms around increasing citizen participation are consistently shown in the literature not to be sufficient in actually really addressing more genuine participation, rather than, so in that sense, if the EU is trying to cope with opening the avenues for more public or civil participation versus expert participation, these literature seem to say, the data seem to suggest, these consistently are disbalanced. It's not even close in terms of sort of privilege of access or implication or power or influence that one has versus the other. And in terms of the sort of knowledge production, this is more of an open question, and something that I'd love to sort of also take more during our conversation today, because it's very much emerging. But what is interesting is that while the EU is regulating a lot of the technologies or a lot of sort of the notions around how, especially from a perspective of privacy and data protection, it doesn't seem to yet be alert enough in terms of the implications of knowledge production would mean, with possibly who gets to be an expert, how expertise is produced going forward actually will impact EU's, or not, in that sense, the input from national levels as well. So I would alert that these two factors are something to be taken much more seriously and be considered, even though they're, especially the latter, is much more so of an emergent one, and how that, where does that leave contestation, but also expertise in the EU. Now, my last 2 points is sort of, I promised that are sort of that the EU has been trying to cope with the contestation of expertise, mostly by procedural transparency. I'm not going to delve too deep into this. I just sort of want to raise this as a point, more so that in many ways, what do I mean by this procedural transparency is efforts in a way to provide a more passive access to information, or more procedures around which are supposed to be opening supposedly avenues that don't necessarily really address, and they cannot per se address, the sort of the diffused processes or the way they actually power takes into account, which then in turn, this could arguably lead into even more damaging consequences, because there's a growing distrust, not only then of the fact that there's more expert-based decision-making, but also that the institutions and the way the procedural aspects they work, there's a growing distrust that they actually don't work for the public. And so in a way, there's even more of a disengagement, even if they exist. Or, as some of the research has also shown, they tend to be not co-opted would be a strong word, but to a large extent overly used by certain actors with particular interests. So it kind of oftentimes goes against this notion of empowering more disempowered voices, but rather opens the avenues for more potential interested parties to actually have the kind of influence. And so it's more like more of the same, but with more legitimized ways of actually achieving those ends. So in the last a minute and a half, I just want to conclude as something that it's sort of a project in the making for me, because I'm more moving from sort of this questions around the role of the individual in the EU has been something that I'm very interested in, not just from an expertise perspective, but really, I've really been for the past few years sort of do people actually care about the EU, and why would they, and how can they actually engage with the EU, which is leading me to think more about legal opportunity structures in the European Union. So I will conclude my intervention sort of by just drawing the attention to, if we want more healthy, I could say, contestation of expertise, because contesting expertise is and should be part of a legitimized proper polity. I think one of the reasons that we see too much of pressure sort of on the input side and too much of the attention on the input side could be possibly shifted if we allow for more contestation by individuals, and by that I mean both civil citizens, but also nonprofit organizations, to actually contest it through law and courts. Of course, maybe my bias as a lawyer comes in here, seeing courts as an avenue. I absolutely recognize that. I also recognize that that could potentially lead to a more litigious culture, or that we don't necessarily want a more centralized and more power to EU courts. But I do think fundamentally it is a good time to rethink legal standing requirements for individuals, because too much of sort of the engagement that can happen, that's happening with the EU, is disproportionately only focusing on input and participation and contesting EU through those means, not enough necessarily through actually, once those decisions are made, how can one actually contest them, and that expertise through the enforcement part, and actually through possibly through litigation. And that's where I'm hoping to go next with my research. And on that note, it's here.
Wonderful.
Thank you.
Thank you so much. Well, Maria, we'll go right over to you, and I'll say something afterwards.
Thank you very much. I've got some slides, so I hope everyone can see those. I hope it's okay for stand, because it makes me nervous if I can't see this past the room. So I'll stand. Okay, so starting point, good, democratically and substantively legitimate decision making is hard. Any jurisdiction, any area of any complexity at all. And what I'm going to talk about today is really the ways in which quite banal procedural law allows us to fashion imperfect and imperfectly democratic outcomes in the mundane and the routine, but the complex, the mundane routine moments where democracy happens. It's not exciting stuff, it's just day-to-day routines of making decisions. And this has really it's become very vivid for me, because procedural environmental law is under extraordinary legislative and procedural pressure in the UK. And the law that is under pressure has its origins in the European Union. And I think there are hints of a similar sort of pressure in the EU. We don't do procedure when it's inconvenient. For example, when we're in a hurry with renewable energy projects. So we see some of this at EU level. The UK pressure, and I think this is really important, runs alongside what I think is an unrealistic reliance on legally binding environmental targets to deliver environmental outcomes. So we've got loss of faith in procedure, extra faith in targets. The rhetorical power of targets is being used as a justification to dismantle long-standing legal processes. So what I'm going to do today, first of all, I'm going to outline what I see as this link between procedure and expertise and democracy. Then I'll turn to the place of targets in our post-Brexit environmental law architecture. Then I'll turn to process pressures. And finally, I'll come back to what this might tell us about expertise and politics. Now, one of the real challenges around EU administration in this area has always been the elusiveness of political institutions that are unproblematically democratically legitimate. I mean, Maria and I have been talking about this for quite a long time, and Chiara and I. Comitology is a genuinely political authority, genuine political deliberation, but it's a terribly long way from the people, you know, if you're thinking about democracy. And perhaps, I don't need to say this, perhaps it's obvious, Well, actually, leaving the European Union does not make those homes for democracy any more simple. So autonomy is elusive in the context of global markets. In the UK, it turns out we've got a really complex territorial constitution, which means that the demos is just not clear. It's no clearer now than it was pre-Brexit. And of course, leaving the European Union is a never-ending process, and that process raises lots of democratic and rule of law challenges. You don't know what you've got till it's gone. So it's a big yellow taxi moment. We keep having them. Okay, so process can be about scrutiny, about compliance and implementation, especially in a European Union of 27 member states. But for current purposes, it's about who takes decisions and how. Process contributes to, I think, the considered, the accountable use of evidence, and it also provides a space for external voices, including environmental groups, broader public. As part of a rich legal framework, including targets, it contributes to credible commitment in the environmental arena. So we could take environmental impact assessment as an example. It requires information evidence to be gathered, to be published. There's an opportunity for expert contestation of that evidence. There's also an opportunity for public voice. So for public contestation of the evidence, for public presentation of other things, of values, of political decisions. The scope and the quality of environmental impact assessment is obviously a matter of dispute, but I think it is a case in which expertise is subjected to a form of democratic scrutiny. And not just the expertise, but also the values on which a decision is being based. And those values are most often, this question about the internal market earlier, these values are most often about economic growth. So environmental impact assessment gives you an opportunity to contest that in all sorts of different ways. Important to say that law alone isn't going to achieve anything very much. We depend on a well-resourced and an active civil society. We depend on a well-resourced public realm. We depend on a culture of inclusion. We depend on integrity in public life, a public authority that really means it and saying it cares about the public interest. Law's not enough, but in the absence of law, in the absence of these sort of settled legal procedures, there are no reliable opportunities to scrutinise either the expertise or the political values on which decisions are based. Of course, the content of procedural environmental law vary. It could support an entirely technocratic regime. It could support a regime where the will of the people is dominant. But we can use procedural environmental law to fashion a relationship between expertise and democracy. It will always be imperfect, but we can fashion that relationship. Okay, so there's a huge literature on targets, which most of you will be really familiar with. They can be technocratic, they can simplify, they can reduce the political debate. And I'm going to touch on that, but really I'm interested in a different point at the moment. And first of all, they are part of that rich legal framework that we need, but also their role in this sort of process pressure is of great interest to me. It's a bit surprising, actually, that the UK has taken on targets in the way it has, because they've always been presented in the past as this weird foreign European thing that we don't really need to do because we're all terribly sensible. And yet, there are loads of targets coming up at the moment, a big political thing. So the Environment Act, hugely significant legislation introduced on the back of a big civil society campaign, and I'm going to resist the urge at the moment to respond to both of the previous papers, but I will say we try to, Karen and I in this book, try to think about something we call political legal opportunity, to try to think a bit more about that legal opportunity structure. Okay, among other things, the Environment Act deepens and extends the place for environmental targets in UK, actually probably just English, environmental law. So targets may be set in any area, at least one must be set in each of a number of broad priority areas: air, water, waste, resources, biodiversity. Although there are broad obligations somehow to address the priority areas, the content of the targets, exactly what is measured, how stringently, over what period, is almost entirely in the hands of the Secretary of State, entirely in the hands of the executive. The role of both expert and democratic input are contingent. It's not that the Secretary of State isn't doing anything around expertise or political input, but it's contingent. It depends on what's convenient for the Secretary of State, because the substantive and the procedural constraints on setting the targets are very, very limited. I won't go into detail on the sort of the content of the Act on setting targets, but first of all, it's been fairly technocratic, inaccessible. I think that's the same at EU level. It's obscure, it's dominated by advisory bodies that we can't actually get at. We know they exist, but you just can't peel away to see what they're actually doing. The Act envisages it as a technocratic process. The Secretary of State has to consult experts, but doesn't have to do a broader public consultation, such experts as the Secretary of State wants to consult. The targets are set in secondary legislation, so in principle, you have this sort of supreme democratic authority of Parliament, but Parliament has really limited impact on the content of secondary legislation. Can't amend it, it can only reject it. Why would you reject a regulation setting targets? Because then you end up with no target, not a better target. Okay, so the contents of the targets are very much in the hands of the executive. There has been a political process, but law has little to say about either expertise or publics in the setting of these targets. 13 targets were set under the Environment Act in January 2023. They are binding, so they're definitely legally binding. Whether they're also enforceable is, of course, a different, interesting question. Some important accountability mechanisms are contained in the Act. Interim targets are being set outside of legislation. The Secretary of State has to report annually, as does the Independent Office for Environmental Protection. But the Act does not provide a mechanism to link the targets with the day-to-day business of government at all levels. Interestingly, nor does the Climate Change Act, which sets our net zero target. So neither the Environment Act nor the Climate Change Act have mechanism to say, and this is how the target means something at the day-to-day level. Both pieces of legislation rely on and assume the continued robustness of existing procedural obligations with their origin in EU law. The ability of procedural obligations to get the targets into the here and now is not good enough, especially given the way the English courts are interpreting the evaluative discretion around the environmental impact assessment regulations. But those procedural obligations that were assumed by the Environment Act and the Climate Change Act are now deeply vulnerable in English law. Environmental assessment, habitats regs are particular targets, loads of legislation challenging them at the moment. I'll just talk about three really quickly. The Nature Recovery Green Paper consults on powers in the Environment Act to amend the habitats regs. This Green Paper also raises the possibility of amending or repealing environmental impact assessment. The overwhelming theme of the Green Paper is a frustration with process. Process has become king, it's crowded out scientific thought. There's an obsession with uniformity of procedure. It's the scourge of modern government. Really weird language for a government consultation paper. And the targets are referred to throughout the paper. So that final quote, the best way to deliver is to have long-term targets and then a free government to deliver those targets. Yeah, that's how we're going to do it. There's no sense that a settled, let alone a sort of legally binding process, might help us to achieve our targets, might help us to manage the process around decision making. I don't suppose procedural law is going to entirely disappear, but it might go when it's inconvenient. Okay, part 6 of this bill, the Levelling Up and Regeneration Bill, a bill meaning it's partway through Parliament, it's not an Act of Parliament yet. This provides a framework for the creation of a homegrown, this is what we're into at the moment in the UK, a homegrown replacement for the habitats regs and environmental assessments. It empowers the Secretary of State, again, executive governments, to make environmental outcome regulations, and they may, so they set specified environmental outcomes. They may also require any development or activity to report against the environmental outcomes, so kind of EIA type situation. And then they might require those reports to be taken into account. The important bit for our purpose is that the EOR regulations could be brilliant. They could be so much better than what we've actually got at the moment, but there's just no guarantee of that. It's in the hands of the government of the day. Okay. And there are powers of interaction with habitats and environmental assessment, which means that environmental assessment and the habitats regs can be repealed and replaced with something that is far weaker in terms of procedural, let alone substantive protections. Okay. The Retained EU Law Revocation and Reform Bill. Some of you will, I'm sure, have heard of this. If you haven't, it's quite an extraordinary thing. This threatens the whole body of what used to be EU law in the UK. So the EU Withdrawal Act created a category of retained EU law. And what that basically meant was that the statute law the day before Brexit was supposed to be the same the day after Brexit by this creation of retained EU law. The bill, clause 1, it's in the House of Lords today, I think, will automatically repeal all of that. All of it, thousands and thousands and thousands of pieces of legislation at the end of 2023. There's the capacity for, again, the executive to save retained EU law if they choose to, and they've got the capacity by the end of this year. There are broad powers granted to whoever happens to be in government by the end of 2026 to amend anything that used to be EU law up until the end of 2026. It's an extraordinary piece of legislation in constitutional terms. I hope we're not now getting too far from expertise and democracy, but I think it's important context. Environmental assessment and habitats regs apply in the day-to-day decision-making, also some high-level policy making. But we have much more going on in terms of constitutional propriety around these sorts of issues. And this is most egregious in the retained EU law bill. If Parliament passes the retained EU law bill, Parliament will have granted the government of the day powers fundamentally to alter our entire legal framework without parliamentary scrutiny, without public consultation, without impact assessment, and without the consent of the devolved administrations. Okay. At the moment, it looks like it's going to go through Parliament. So there's something really very extraordinary coming out of the back of Brexit. There's a lot going on here, and there's quite a lot to be worried about, and I don't think any member state of the European Union or the European Union itself can afford to be complacent. You know, that comes from some quite brutal experience. But what about expertise and politics? I think it's most obvious that the targets that I was talking about have a technocratic element. Okay, there's a technocratic However, I think there's a populist strand. I don't think that's inconsistent. The harder I look at these things, the harder I find it to separate technocratic and populist approaches. There are no sort of grand or explicit appeals to the people going on. So perhaps we're better off without labels. So even ignoring the label. First of all, there is a broad elite, but not only elite, there's a broad political consensus on the importance of environmental protection. And that's kind of reflected in the targets, whatever the content of the targets might be. As you know, we've got these targets, and that is seen as an achievement in itself. It's as if there were no politics in what we value, what we prioritise. The targets are posing apparently simple answers to very complex problems. Secondly, we get a rhetorical and a legal kind of elision of the language between targets and outcomes. That's in the Levelling Up and Regeneration Bill. Between targets and delivery, we saw that in the Nature Recovery Agreement. And this elision between targets, something we aspire to, and outcomes and delivery, something we've done, is a really sharp manifestation of the missing procedural implementation piece of the picture. Success is assumed, and the difficulty of delivering, the difficulty of outcomes is just overlooked. You know, who bears the costs? Who takes the benefits? How is this going to work? I should say that there's been a recent government paper where it talks a bit more about delivery rather than just assuming Environmental Improvement Plan 2021. And even there, when it talks about delivery, it's primarily about technical problems, not that it might be politically or socially difficult. Third, there's this association with lawyers. And that's sort of classic elite bashing. That goes back as long as people have been bashing elites. Yeah, I'm not gonna take you through that. I do love that little bit about EU law. Too many lawyers, not enough scientists. I disagree, but anyway. The fourth thing, and perhaps the most important, is the way that targets are being used to justify explicitly this loss of law, this loss of procedural law. So the top quotation there, you've already seen. The bottom one is about, you know, remember how big the retained EU law bill is? Remember how meaningful it is. It does not change the environment. Well, that's okay then. And we remain committed to delivering our legally binding target. You know, and all of those thousands of pieces of regulation are just sidelined. Okay, so the loss of procedure reduces space, both for legal and political response and action. Targets do pose some constraints, but we know they don't pose sufficient constraints. They're too far in the future. The duty might be owned by the wrong party. Death by 1,000 cuts. No individual decision seems to really matter as far as the target goes. Relying on targets and undervaluing environmental procedural issues and procedural legitimacy has a populist avoidance of politics to it. It also has a technocratic avoidance of politics to it. Simplified, decontextualized environmental targets, indicators are always somewhat technocratic. But in the absence of any binding procedural obligations on the production, scrutiny, use of evidence, the fear is that not only political disagreements, but also expert contestation, the quality of expertise, that will also be sidestepped. So technocratic doesn't quite do it because expertise is also vulnerable here. It could be used only when convenient. I don't want to exaggerate our situation in the United Kingdom. We do still have elections and all of that sort of thing. And I do think the targets are part of a rich environmental law framework, but so are procedures. And these are really significant shifts in the way we think about environmental law. And I think that they're relevant to expertise and democracy. They're also relevant to other jurisdictions. I'm going to return to something I said right at the beginning. Procedural law allows us to fashion imperfect and imperfectly democratic outcomes in those banal moments where democracy happens. Chiara and I, in this article, we use the expression, we say politics happens, whether you like it or not, politics happens. And the question is, who does politics? Okay, and that I think is what's going on here. It's Westminster, it's Whitehall, it's government that's doing the politics here. Finally, I'm not arguing procedural environmental law is perfect or even could ever be perfect. It's certainly not going to save the world, but I do think we can think harder about its role in constraining the powerful and in making our environmental ambitions meaningful. And I'll leave it at that. Thank you very much.
Thank you very much, Maria.